Namaste everyone. This is a discussion that we are having under the aegis of the Pan-India Legal Literacy and Legal Awareness Program organized by the Center for Environmental Law Education, Research and Advocacy at the National Law School of India, University, Bengaluru. This is a program which is under the aegis of the Department of Justice, Ministry of Law and Justice, Government of India. In this discussion, we will be speaking about what is most infamously called as check bounce, or in legal terms which is called a dishonour of cheque, and how does one behave when there is a circumstance of dishonour of cheque or check bounce issued to him. Before we move on there, I would want to discuss as to what is a cheque. For this, I have a demo check that is put across on the screen for your reference. Now if you look at this, a check has a lot of details, and it is necessary that every detail of this is available before you understand what is a dishonour of cheque or a check bounce. Now if you notice, the first detail that you will definitely observe is that there is the name of the bank that is there on a check, which every person who receives the check has to ensure that there is a name of the bank that is mentioned. Along with it, there is also the details of the branch, the address where the particular bank is situated, which you will find on a check. Second thing that you will notice is that the check that is issued to you has something called a date of issue. In the picture that is there in front of you, the date of issue is 17 September 2017. The next detail that you will find is pay to. If you are receiving the check, then the check will read pay Mr. So and so, pay Miss so and so. In the given illustration, it is HSBC car loan account number for which it is paid to. The next detail that you will find in a check is the amount. Now please note, the amount is always entered in both words and numericals, and it is necessary that both the word description as well as the numerical description has to match one another. The next detail that you will find is the account number of the person giving the check. Now that is also something that you will find in most checks in case it is issued by one particular person. If loose leaves are collected, at those circumstances there is a possibility that this account number may be handwritten also. In those circumstances, you could just notice that there is a difference in the manner that the check is there. And the last detail that you will find in a check is as to the person who is issuing the check to you or the person who is giving the check to you. Now, the reason why we are discussing this is because when, let us say for example, you give a check or you receive a check, and if the same is not honored or if the same is not cleared or paid by the bank when you submit it for payment, and there is a refusal for payment of the same, in those circumstances it is an offence that is punishable under the Negotiable Instruments Act of 1881. The punishment for the same extends up to a period of 2 years and may be also imposed with a fine which is equivalent to 2 times the amount of the check. In the given description, 2 times the amount of the check, if you look at it, it is close to around 2,47,000. That is the extent to which penalty can be imposed in case a check is dishonoured or if a check is bounced. Move on to the next leg of the presentation. You have submitted the check, or the person to whom you issued a check has submitted it before the bank, and he receives from the bank something called an intimation when the check is deposited. The intimation is that the bank refuses to pay the person who is depositing the check, it could be you or somebody else, for the following reasons: that there is one, insufficient funds in the account, or there is some other instruction that is received from the person who gives the check, who is also called issuer or drawer. Now that could be like stop payment. This is the particular instruction that is given across generally when there are any other specific instruction that is given by the issuer or drawer. Now please note, there may be certain other circumstances also where the bank refuses to make the payment, That could be for one of the reason that the account is closed at the time of submission, or before the date of submission the account is closed. Like say for example, I issue the check on April 1. Yeah, it's April Fool's Day. And on April 7th, you submitted before the bank for payment, but the bank communicates to you that the account holder has closed the account on April 3rd. Now this is one of the particular reasons or peculiar cases that you may also encounter. Please note, in all these circumstances, regardless of what the reason is, the person can be held liable for the offense of check bounce or dishonor of checks. What do you do in case there is a dishonor of check, or the check which you presented to the bank has bounced? The person who receives the check is always called the payee, and if you are the payee, you should send a notice to the issuer or the drawer for him to make repayment. This is usually called a demand notice. So in other words, a demand notice is to be issued to the issuer or drawer within 30 days from the intimation from the bank, and this notice should ask the person, that is the issuer or the drawer, to make a payment within a period of 15 days. Second thing is, you may ask, in certain circumstances, how do I identify who is the issuer or drawer? Please note, if the person who gave you the check is an individual who is giving in his individual capacity, like say for example, you have given a house on rent, the person who is staying inside is a tenant, and he is a particular individual who is staying there for the period of so many days and other things. So in those circumstances, he will be the person to whom you will have to issue the notice. Now it may so happen that you are a businessman, and in your business and dealings you may come across certain companies. Now when I say company, it could be a private limited company, it could be a public limited company, it could be a partnership firm, it could be a limited liability partnership and the like. In those circumstances, you will have to issue the particular notice to the company and its directors. Where it is a limited liability partnership, to the LLP firm and its partners. If in case it is a trust, so in certain circumstances you will find that educational institutions are formed by the way of trust. If you have received a check from a trust, then in those circumstances you have to make the notice to the trustee of the trust also. And in case it is a partnership firm, you could write it to the partners of the partnership firm and have the notice issued. And after issuing this particular notice, you will have a right to approach the metropolitan magistrate if you are living in a metropolitan city, or the judicial magistrate first class in case you are living in certain other cities, to file a complaint. Please note, this demand notice is always a precondition before you go before the magistrate and file a complaint. When do you file this case? Now I have given you that before filing the case you are required to send the notice. From what time do I get the opportunity to approach before the magistrate? Please note, from the 16th day of non-payment by the issuer or the drawer. If you notice in the first slide, we spoke about a demand notice which is asking the particular issuer or the drawer to make the payment within 15 days. It is from the 16th day of non-payment that you get a right to approach before the metropolitan magistrate or the judicial magistrate first class. And always note that you will have to approach the particular court within a period of 30 days from the 16th day. Now you may ask, there is COVID going on, or there is some other reasons, you were traveling, somebody in your family was not well, or certain other reasons because of which you could not approach the court within a period of 30 days. In those circumstances, is the remedy lost? That could be a question that would be running in your mind. Please note, if 30 days are over, you can always make an application for condonation of delay for any period beyond 30 days. There is another alternate that is also available with you, that every time a check is presented, it can be presented any number of times. So in case the timeline is over and there is a long or inordinate delay, then you can represent the check to the bank for an intimation. In those circumstances, representation, the date of re-intimation by the bank after representation, that will be counted for the issuance of notice. And from there, you will have to follow the same steps, which is issuance of a demand notice to the rightful person and filing the case from the 16th day onwards. Now, this is the manner in which you are required to deal if there is a check bounce case. We hope this discussion was fruitful in understanding the manner in which you are required to deal with a situation of check bounce or dishonour of checks. Do subscribe to our YouTube channel for more such legal updates and legal awareness. You may also reach out to our pro bono legal literacy assistance number, which is on the screen. Thank you. Namaste.